So पहला क्वेश्चन अपना हेमंत जी का है, for how long does a society office have to wait for a nominee to come forward to claim their membership or legal hire, come forward to claim their hireship in the society?
So the
Is there
waiting
any time
period,
frame?
there is no time frame as such, but let us look at it in a different angle. You have nominated, you have allotted a membership to a provisionally to a person, and your job is finished. If somebody else would come forward and say, I am legal here, in that case the question will be reopened. So waiting period is not, provisional member is always provisional. It will not become automatically final membership even after 10 years. So the provisional member has to also prove within a certain kind of time that he is a legal heir. Society can kept pestering him each year, that reminding him that you are a provisional member, membership has been provisionally granted to you, hoping that you will prove the legal heirship. So you are asked and requested to do the necessary steps. So you can give him a yearly reminder, so to say. Or in a general body meeting, you can pass a resolution that following members are provisional members and they are asked to file their documents within next 6 months or 1 year, what kind of thing. So there is no definite kind of time frame, but this reminder kind of thing is a good solution for that.
Question, what happens to such problem if none come forward? What step the society office need to take if none come forward?
आपने तो ये देखा है कि we say it is a co-ownership. What we say, it's a tenant co-ownership of society. Society is the plot as well as the building belongs to the society. It doesn't belong to any other person or any government or any corporation or whatever it may be. So naturally, it would become a common property of all the persons. The chairman cannot say that I being a chairman, let me have a first right over the property. That cannot be done. So it is a common property and it will remain as a common property. Only we are giving rights of use to the members. Member is not owner. Member has only right and access to the property. Membership is ownership is controlled in that sense. So finally the property will go to the society only.
Mr. Pinto has a question. If one is already a nominal member and the process of bringing the legal hire is on the basis of a LA, what will be the process now that the new section has come in? Has any change to be made in the certificate, changing it to nominee to provisional member, or continue to be made as it is with the nomination?
Share certificate will remain and continue to be as if there will not be any change in the status, but you remind him to bring in LA. Actually, we should understand that ownership rights are governed by Transfer of Property Act and Contract Act. So these are the major acts, and housing society is a sort of subsidiary or say ancillary kind of act. So ownership is not decided within that. So Housing Societies Act is only limited to the membership, shareholding, and right to member and right to govern the society and maintain it. So legal heirship is not decided through. You have to go to the court and obtain it, and thereafter you will become a final member. Yes, please.
Yeah. Hemant has another question. I think will clarify a lot of doubt of the people. Is it a must for those many joint owners to fill the membership form and pay the requisite fee? If there are 4 joint owners, do all the remaining 3 also need to fill the requisite form and fee?
Actually, we need to look at the word joint. So there is application is also a joint application. There is not a separate and individual applications. So all the details of all the 4 persons are to be filled in one application, and share will be remain held jointly by all of them, and their names will appear. All names will appear on one share certificate. There are no separate certificates for each person. So each person need not file a separate application for membership because they are jointly holding the property and they have to move together jointly only. And society will treat them as a jointly. Now is there, how do they share the maintenance among us themselves is their own issue. Society need not bother about it or need not govern it or need not direct them that you pay 10%, you pay 25%, you pay 50%. In such a case, it will be difficult for the society to manage the maintenance account for that flat. Society will keep only one account and it will accept check from either of any joint member. It has no issue for that. So joints are always joints, they are not separated, so they have to move together and act together. But only question arises while at the time of voting. What will happen at the voting? All the four names will appear in the list. If first is attending the voting, then that's fine. If it doesn't come, the second will come. If both are absent, then third will vote. If all the three are absent, then fourth will vote. So then there is one more thing. His physical appearance itself is his intention to vote. He did not bring in a letter from all the three persons. But in case of associate member, you have to have a written consent. So written consent and written letter is not required for joint member. Joint member has to just go and say, I have come to vote, please grant me time. Because first two persons are in the list are absent. So this is the thing. Please.
Thank you very much. I'll take another question of Mr. of Niranjan. Provisional member can attend AGM and also vote, but can he appoint a nominee? Can a provisional member appoint an associate member?
Yes, of course. Provisional is a not provisional membership is a full membership. There are no restrictions. He has only one restriction, that is that he has to prove his membership through LA. So he'll bring in LA and he'll become full member. But in the meantime also he has every right, he has every duty cast upon him, and he can also appoint an associate member. So
Except he cannot sell the property because right and title interest is not transferred in his name.
definitely.
Yeah.
Definitely.
I will go to the next question. Can a member appoint an NGO or a religious or charitable institution as a nominee? Prior permission of charity commissioner or any other statutory authority required to be taken?
This talks about a legal body being appointed as nominee. So, of course, permission of the charity commissioner is very much essential. And yes, in my opinion, if a religious or charitable trust can also be appointed as nominee. Actually, let us say that if a member wants to gift his flat to a charity or to a trust or to a religious trust or to a temple, he can very well do it. And so why not he can always also nominate them. But of course, permission of the charity commissioner are required. And in case of NGO,
Yeah.
this is also possible. NGO has to be registered, it has to be a body corporate, and it should be a live entity. How a legal body can be live, that question would come up. So a legal body would remain live if its accounts are audited, if its returns are filed, if it is abiding by all the laws and rules. In such a case, it is a live person. If its audit is not conducted for last say 5 years, 10 years, 9 years, then it's only a merely certified certificate and not an NGO or not a legal body. So liveness in such a cases is that registered society complies with all the laws which are applicable to that organization.
Can a member who is the trustee of some NGO who does not have any business with the society become a managing committee member?
What is the business in the society? What that does means? So I presume that he is not using the flat or he is not coming to the society, and the trustee of some NGO who does not have, why a trustee of some NGO should become member, that is not clear to me, but I'll presume this question in another way, that an NGO is holding certain flat and it is holding membership. Is that, if that is clear, and if, as we discussed earlier also, a individual holding a flat and using it, and his family members are also using the flat along with him, is a very visible and clear and set pattern. But in case of an NGO holding a flat, or a company holding a flat, or a partnership holding a flat, in these cases, the society will have to have a clear picture that who will use this flat, in what manner, and for what purpose the flat will be used. So the society can always ask that NGO or the trust or the company or the partnership firm to set certain rules for right and use to the and access to the flat. So that is always possible. The society can ask questions.
Mr. Lakshman has a question. Provision member can be a part of committee.
Of course, if he is chosen by the general body meeting, he can become a part of the committee.
Next question है Mr. Grish का. I'll read out. Still on the first owner name. Past two owners are not submitted the document to the society for name transfer on share certificate. As old flat owner as well as society has not issued the share certificate to any one member. Share certificate was made in 2008 after society registration but not issued to the member. It was kept in society office. Only society committee has decided to distribute all the members, so old members are not transferred their name. Now I have submitted the all document to society as per bylaws for transfer name on share certificate to the my wife name. But on share certificate is on the first owner name. Society has directly transferred to my wife name, or they need to add first two and first, second, and third owner name as they have added my wife name. Please advise.
So there is a missing kind of link in between. Two persons are have to be placed on the share certificate. Actually, property record is maintained separately, individually in the sub-registrar's office also, we know that. So index 2 are generated each time the document is registered and property is transferred. So the sequence of transfer of ownership and is also recorded in the government offices. So you can obtain the last indexes available in that office, and if share certificate is also in alignment with the government record, that's good. But if it is not, still it doesn't affect the right of your wife to have ownership. So it is not a kind of a defect. But if it is cleared and if it is kept in alignment with the government record, that's good. So you go for that and insist upon that. The two names are appeared, and then fourth name is appeared also. Is that clear?
Nikita Modi has a question. Does power of attorney holder, in case of a member living abroad, make application to registrar to dissolve present MC if it is not functioning properly? So can a member who is holding do this?
Actually, making a complaint to the registrar is not a big thing. Please understand. It's only a kind of intimation to take cognizance of certain things. Registrar has to attend to the affairs of the society, and it is his duty to check that society is acting as per the law. It is following all the rules, all the provisions of the act, and also the provisions of the bylaws. So it is his abundant duty. So what this fellow is doing, that for certain reasons, for business purposes, for some other kind of things, that he is staying abroad and he cannot frequently come to the society and check with his flat. But he is worried about the maintenance, he is worried about the building, he is worried about the society. So he has to bring in certain things to the notice of the registrar. So he can always appoint an advocate. An advocate is a permitted legal representative. There is no issue. And power of attorney holder is also legally permitted representative. So they can always go and prove that they are legally appointed. And in question, if later on the fellow from abroad says that, oh, I have not signed those documents, in that case, the attorney will come in trouble. So you have to take care. So getting appointed as nominee. Sorry, attorney. Yes.
Thank you. Mr. Pinto has a question. As per the new bylaws, if there is a document of a family arrangement, then does that member become a final member, or does that member still have to get a succession certificate?
Family document or a nomination, both things are temporary. So the temporary membership has come into the picture. Nomination is also not a final thing. And so family document is also not a final thing. He has to prove legally only these are interim arrangements and provisional arrangements. So LA is necessary.
So now Mr. Hemant has another question. Erstwhile committee had given NOC to a member to run tuition in his flat, and this was a year ago. Today's scenario has changed. These are full-blown education classes. The member today has converted the entire flat as a tuition room. Today, it is a nuisance, but the said member says that there is an NOC. What is to be done now in this case?
First thing is that bring the nuisance has to bring the nuisance to the notice of the committee. So the committee will go to the general body meeting and put the nuisance and the grievance of the member before them, and the general body together will take the decision whether to revoke the NOC or continue the NOC with certain charges or some other riding features. So NOC once given cannot be withdrawn is not the law. Only NOC, say consent consent given in the marriage is continued till death, but consent given in case of such use of flat can always be withdrawn, but it has to have to pass a general resolution of the general body meeting. So that issue can be resolved in that way.
Dr. Sanjay has a question. He says that what action a nominee is to do to become a member as higher. Someone says letter of administration is required. What format of this letter and how to obtain it? Please share process and steps.
This is not the forum and time and duration available for us to share the process. So it is better that you please approach an advocate and seek his guidance and go through the process. It's a very simple process. You have to apply to the local civil court and say that we are legal representatives of. These are governed by laws of succession. So laws of succession are different for Hindus and others. So there are some different things. So you have to go for that. So advocate's advice is advisable, and it's very simple process. It would take 3 to 6 months, and then LA is available, and LA to the society will become full member. Yes.
So, Patil, if I understand his question correctly, there are two questions. One is saying ki if there is a nominee is already there, is there any document which needs to be submitted to become a provisional member? So maybe perhaps if he is a nominee, he just need to inform the society that he is a nominee and he has to be a now provisional member till the time he submits his letter of administration. And second process, of course, you have already explained to him how to obtain the LA. So in case he has to approach to the advocate and then follow the process of the obtaining LA. So I think this suffices the purpose of his question. Society makes nomination as member. Won't any legal process or heirship? Is this valid? What will happen if such member sell his flat later? Dr. Sanjay is asking this question again. Society
Nominee,
makes nominee as member.
the buyer will what we always say in the law that buyer be aware. So the जो परचेस कर रहा है उनको ये सोचना है कि नॉमिनी से लेना है कि नहीं लेना है. So all the dangers associated with buying property from not proven legal heir, not proven legal authority, not proven owner are always there to be faced by those people. In case of society has to just keep the record of whatever happens to the ownership of the.
Hemant has a question. Provisional member, as per the presentation, said he has a right to vote. But question is, can he stand for election or can he be a part of the society committee? I think again this was very well explained that yes, provision member have all the rights of a member except that he cannot sell his flat till the time his legal rights are transferred to him. So I'm sure since he is a provision member is a member, he also can do this. And Mr. Patil has already explained that he can vote committee. I'll now go to the next question. Nikita Modi has what is one of the joint member dies and they have no legal heir? What about the right of the second joint survival member? Does she have entire right over the property name of the share certificate transfer after death of the survival member?
What if one of the joint member dies and they have no? What about the right of the second joint surviving member? Does she have entire right over the property, name of share certificate, transfer after death of surviving member? This is not the when a person dies in test or when a person dies without leaving legal heirs or without nominating somebody. In such a case, joint member who wants to become member of that portion also will have to prove the LA, and in that case, she can always get the rest of the property in her name. In the meantime, she is using, there is no issue about it. She has to prove the legal heirship for that portion also.
Nikita has one more question that can interest on maintenance be charged during the lockdown by the society or can it be waived off or any moratorium?
Question is unique to the period of this time. As we know that Government of India has issued a guideline to all the banks that interest during COVID period should be treated separately or should be reduced or should be recovered in installments, and should also be given an additional loan for the company or unit or factory. So waiver is also possible. Reduction of rate of interest is possible, or say no interest is also possible. But only one thing is necessary for all those things, that you have to pass a resolution of general meeting. So you sit together, said that COVID period will not attract any interest, so member can always avail of this proper facility. Now,
Yes.
Pune Municipal Corporation has published an advertisement that property tax interest to the extent of 80% is waived if it is paid within certain period. So this also can be done. So you waive interest up to some extent, you waive interest fully, or you give installments, or whatever. Choice is yours. Only general body meeting resolution is required.
Yes, thank you very much. And I think indeed good the reply was this needs a AGM approval. This needs a resolution by the AGM. Then of course all is possible. Mr. Pinto has a question. Does the associate member have to get a written consent only at the time of becoming an associate member, or does he have to get a written consent every time the associate member attends an AGM or SGBA? We have to read the consent for what period it has been granted. So if it is a one-time consent, then it is a one-time ticket only. If it is a pass kind of consent, at multiple journeys are possible, then that is a monthly pass or say annual pass or whatever. So the wording of the consent would decide the nature of consent. Nikita has another question. How can the membership be transferred to a three nominees nominated on the death of a joint member, one of them residing abroad? Residing abroad is not a restriction in accepting or holding a property in India. There is no issue about it. Only whether he is ready to or not, he'll make it clear and then it will be done. So membership can be transferred, and nominee need not be present for the meeting in which the membership is granted. Membership is granted on the basis of the documents submitted to the committee. So committee will
scrutinize the documents and give its decision. So his presence is not a restriction or is not a hindrance. Society can go ahead as per the documents, or even society can inquire with him, make a call or send an email, talk to him, or obtain his additional information. So these are not actually possible impediments.
Okay. Lakshman has a question. Can I issue an NOC for sale of flat to nominee?
Society can always sell flat to anybody, even third person. Nominee is a good choice. Transfer is easy, possession is easy, everything is easy. So these are transferring a property or selling a property is an individual decision. Society has only to keep record of transfers.
Okay. Samir Roy has the question which says that if there is only one surviving nominee, will the nominee have to probate the will?
Yes, of course. Of course, yes.
Yeah. Dr. Sanjay has the one question. It is just written in the chat box. Member sells flat and submitted transfer set and registered sale deed to the MC. Before MC could transfer, member writes to the MC that there is some payment is still due and hence transfer should not be done. Now, once registered sale deed is available and transfer set and possession is submitted by the selling member, should MC take note of the protest or should transfer to the buyer based on the document?
It's a very interesting question that society is presuming that it is a government record keeping office. It is not so. So you are acting on behalf of a member. So request of a member has to have a predominant kind of thing for you. If member has not got the proceeds or he doesn't want to sell the flat to that person, even if the document is registered, there may be some issues between the buyer and the seller. They'll go to the court, they will settle the issues and they'll come to you. Why you are in a hurry? What kind of hurry you have? Why you want to throw out the member? That is not expected. You please wait. It doesn't matter for you if you write in 2020 that this flat is transferred from A to B, or if you record this event in 2025. Nothing matters to the society. Society should get its maintenance in time. That's enough. So I hope that you will cooperate with the member.
Yeah. Mr. Dilip has a question.
जी जो राइट्स जो एक्सरसाइज करने का था ना, अभी नावेडेज क्या मेजोरिटी सोसाइटी अभी रीडेवलपमेंट में ही जाती है और वहां पे ही हमको राइट एक्सरसाइज करने को नहीं मिल रहा है, इसलिए हमने क्वेश्चन किया है कि अपना ये जो वेबसाइट बनाना जरूरी है कि नहीं, 79 और बैंक गारंटी है, क्यों कि क्या रहता है कि यहाँ पे क्या मेजोरिटी होके डिसीजन चला जाता है, लेकिन इंडिविजुअल मेंबर का या तो माइनॉरिटी का सब राइट्स रह जाता है।
दिलीप भाई, माइनॉरिटी के लिए तो राइट अभी देखिए कि हमेशा के लिए ये एक रुका हुआ फैसला ना हो, इसलिए हमने जनरल मीटिंग का प्रावधान किया है। 51% ऑफ मेंबर्स देयर। हमने ये भी लिखा है कानून में कि जो मेंबर फ्लैट नहीं खाली करता उसको खाली करना है और सोसाइटी को पोजीशन देना है या फिर डेवलपर को पोजीशन देना है, तो ये भी कानून में आया है। फिर भी एक मेंबर बहुत ही दुखी है और वो इसके साथ सहमत नहीं है, उनके कुछ और इश्यूज हैं, उनको नहीं लगता कि इसमें काफी ट्रांसपेरेंसी बरतनी चाहिए, उतनी बरती नहीं गई है। तो इन सच ए केस देयर इज वन मोर राइट टू ईच मेंबर पर्सनली, इंडिविजुअली, he can go to the cooperative court, challenge the general body meeting resolution and obtain stay there. Everything will be stopped till inquiry is finished at the end of the cooperative court. This right is always available to individual member. There is no ban on that. So दिलीप भाई, वो मेंबर कोऑपरेटिव कोर्ट में जाके जनरल बॉडी मीटिंग का रेजोल्यूशन चैलेंज कर सकते हैं, सारी बातें कोर्ट के सामने रख सकते हैं और उसको स्टे लेके आगे की इंक्वायरी, आगे का कंस्ट्रक्शन का वर्क या फिर आगे की प्रोसेस रुकवा सकते हैं। तो ये राइट उनको है। तो देखिए कि ये तो बहुत आपका इट्स काइंड ऑफ अ टेस्टिंग काइंड ऑफ थिंग, आपका पेशेंस इसमें टेस्ट किया जाता है बाकी के मेंबर का आपके ऊपर जो भी कोई प्रेशर है वो आपको बेयर करना पड़ता है. एवरीथिंग इज टेस्टिंग टाइम. तो पर राइट तो है, आप कोऑपरेटिव कोर्ट में जा सकते हैं.
वनदेश का एक क्वेश्चन है, इज देयर एनी टाइम लिमिट फॉर अ न्यू मेंबर ड्यूली ट्रांसफर्ड इन द सीट्स बी ब्रॉट इनटू द एमसी इफ प्लेस इज वेकेंट?
देखिए, आपको ये बात समझनी चाहिए कि सोसाइटी का मेंबरशिप कानून में तो लिखा गया है कि कंपलसरी नहीं है, वॉलंटरी है. ऑर्गेनाइजेशन भी वॉलंटरी है, हमें पता है. अ सोसाइटी कैन सिट टुगेदर एंड से दैट वी आर डिसॉल्विंग आवरसेल्फ, वी वांट टू पुट आवरसेल्फ इनटू लिक्विडेशन एंड वी डोंट वांट टू एग्जिस्ट एज अ सोसाइटी. तो वो भी है. पर देखिए कि मैनेजमेंट कमेटी पे कोई पोस्ट वैकेंट रहती है वो कब भरनी चाहिए? एज सुन एज पॉसिबल तो भरनी चाहिए. नहीं भरा तो क्या होगा? कुछ नहीं होगा. Because people who don't want to come forward, they will not come forward. So there the vacancy will always remain. It is again a voluntary kind of thing. I don't want to participate in the affairs of the society. So being a voluntary organization, I'll keep myself away. Let them do whatever they want to do. And if nobody does anything, in such case, registrar will take over. So time limit is not prescribed in the act for the filling of the vacancy. But only one time limit is of course prescribed. If vacancies occurred within less than half of the period, the vacancies has to be filled with election. If it is more than one half period, then it can be filled with nomination. Again, the nomination has a rider. Only maximum two persons can be nominated. So these are the modes and things about the filling the vacancy on the board of directors.
Hemant has a question. Nominee is a trustee and does not have a right and title in the property, interest in the property. So can nominee's application to sell the flat be processed? What if we ask for an NOC as required by the buyer for selling the flat?
Actually, काफी जगह पे ये बोला गया है कि NOC is not required for selling the flat. You can just go to the open market, sell the flat and forget about it. That is the thing. But if somebody is asking to the society to give NOC, if a nominee is saying that please give us NOC, society should say in clear terms and words that you are a nominee, you have not proven your legal heirship, so NOC is not granted. If this letter is given, the buyer will remain aware and buyer will persist on him and pester him to produce his legal ownership. So this is a precautionary kind of thing and society should not keep away from its duties. Society should give a letter in clear cut terms that this is the situation and buyer should be, and then buyer will become aware about it. So society need not give NOC to a nominee who has not proven his legal heirship.
Thank you, sir.
Secretary is not residing in the CTS but somewhere else on leave and license basis. If the secretary is not available for any type of correspondence, what remedy can the member have against the secretary?
First is that you go to the registrar's office and make a complaint. And second is that you move a resolution in the incoming general meeting. All those persons who are not residing within the society should not become committee members. Or even you can amend your bylaws and put this as a basic restriction that the resident members can only become committee members. So these are the remedies available to you. And if actually we need to understand this. This being a kind of a volunteer kind of thing. So volunteers are volunteering themselves but not performing the duties are not good volunteers. So you please remind them that either you come back to the society as a resident or vacate the seat for some other resident.
Yeah.
Please.
So now we have a last question. Mr. Ranjan want to ask. Can you unmute him? Rajan. Sir Rajan?
हेलो,
Yes,
राजन
please go
पटले
ahead.
जी को अनम्यूट करें. अविनाश शिंदे.
Hello.
राजन पटले
Hello.
जी. Yes, राजन जी.
Sir, can I ask my question in Marathi?
बोला.
Actually, I'm not getting certain words for those Marathi. Actually, आमच्या बिल्डिंग मध्ये काही कमिटी मेंबर्स आहेत. त्यांनी स्वतःच काही इलिगल गोष्टी केलेल्या म्हणजे स्वतःच्या दुकानात पोटमाळा असेल एका सेक्रेटरीने स्वतःच्या दुकानात पोटमाळा केलाय, एका कमिटी मेंबरने स्वतःचं घर हे एक कमर्शियलला दिलेलं आहे, एका कमिटी मेंबरने एक्स सेक्रेटरीच्या नाकाखाली एक पिलर काढला गेलेला आहे. मला हे राईट्स अँड रिस्पॉन्सिबिलिटीज ऑफ अ कमिटी मेंबर आहेत, ते कोणत्या सेक्शन खाली त्यांनी कसं वागलं पाहिजे ते कुठे लिहिलेलं आहे. कारण हे लोक लिकेजची पण कामं करत नाही आणि बाजूचा एक फ्लॅट आहे जो इलिगल बीएमसीने तोडलेला आहे, तो पण त्यांना एक ऑफिस म्हणून हवा, जे ऍक्च्युअली गरज नाही. जेव्हा जसं माय सोसायटी क्लबचं एक नॉक नॉक सॉफ्टवेअर आहे, ते एकच सॉफ्टवेअर सगळं काम करतं, तर त्याची पण गरज नाही, तरी पण हे असंच चालू आहे. मग त्यांचे राईट्स अँड रेस्पॉन्सिबिलिटी ड्युटीज हे आपल्याला कसं कळेल, आपण त्यांना कसं सांगू शकतो? थँक्यू.
ऍक्च्युली रंजन भाई, तुम्ही एकदा बायोलॉज सगळे वाचून बघा. बायोलॉजी मध्ये बऱ्याचशा गोष्टी आहेत. एक नंतर महाराष्ट्र सहकारी संस्था अधिनियम आणि नियम हे दोन्ही पुस्तकं वाचा. परंतु मी असं समजेन, म्हणजे तुम्हाला मी सोप्या भाषेत सांगतो की जसं मी माझ्या वैयक्तिक मालमत्तेचं संरक्षण करतो, त्यासाठी पूर्ण काळजी घेतो, तशीच काळजी कमिटीने संस्थेच्या प्रॉपर्टीसाठी घेतली पाहिजे. आणि ते जर घेत नसतील तर राजन भाई, आपल्यासारख्या लोकांनी कमिटीवर आलं पाहिजे. आता आपल्याला कमिटीवर येण्याचा काय मार्ग आहे? एक तर वेळ दिला पाहिजे, ही पहिली गोष्ट आहे. आणि दुसरी गोष्ट, बाकीच्या सभासदांनी सपोर्ट दिला पाहिजे. बाकीचे सभासद कधी सपोर्ट देतील? या मॅनेजमेंट कमिटीची ही काय कृत्य आणि कृष्ण कृत्य उघड होतील, त्यावेळेस ते लोक तुम्हाला सांगतील की नाही आता तुम्ही जबाबदारी घ्या, आम्ही तुमच्या मागे आहे. तो मॅनेजमेंट कमिटीवर जाणं ही जबाबदारी स्वीकारण्याचं काम आहे. आता कोणी पिल्लर रिमूव्ह केला, कोणी इलिगल तोडलेला फ्लॅट रियाक उपाय करू बघताय, या सगळ्या गोष्टी कॉर्पोरेशनकडे तक्रार केली तर ते मार्गी लागतात. नगरपालिकेचं कामच आहे ते. आता पिल्लर जर तोडला असेल तर इमारत सुद्धा वीक झाली असेल आणि कदाचित ते स्ट्रक्चर डॅमेज करणे, दिस इज अ काइंड ऑफ क्राईम. गुन्ह्याला कसं ट्रीट करायचं आणि गुन्हेगाराला शिक्षा करण्यासाठी कसा प्रयत्न करायचा हे तुमच्यावर अवलंबून आहे. काही काळासाठी आपण एखाद्या तज्ञाची मदत घ्यायला हरकत नाहीये. बोला. हा,
मी स्वतः गिफ्ट डीड केलेली आहे. गिफ्ट डीड करून म्हणजे त्यांनी सुद्धा साधी एक्नॉलेजमेंट द्यायची सुद्धा हे केलं नव्हतं. पाठपुरावा करून मी गिफ्ट डीडच्या मागे लागलोय. अजूनही ते गिफ्ट डीडच्या पुढे काही डॉक्युमेंट सारवासारव केली जात नाही. आणि मला गिफ्ट डीडच्या अगोदर ज्या लिकेज संबंधित तक्रारी होत्या, तर त्यांनी सांगितलं की तुमची कोणतीही लेखी, आम्हाला सांगितलं तुमच्याशी बोलायचं नाही, कोणती लेखी तक्रार पण घ्यायची नाही. शेवटी मग मी गिफ्ट डीड केलं आणि गिफ्ट डीड केल्यानंतर कळलं आता बाबा ह्याच्या नावाखाली फ्लॅट होणार आहे, पण हा आपले सगळे भांडे फोडणार आहे. तर त्या लोकांना गिफ्ट डीड पण आता पुढचे डॉक्युमेंट्स करायला उशीर करतायत जाणून बुजून. आणि कमिटी व्हायला पण रेडी आहे.
नाही, ठीक आहे. आता जो गिफ्ट डीडचा भाग आहे, तो गिफ्ट डीड तुम्ही रजिस्टर करून घ्या सब रजिस्ट्रारच्या ऑफिसमध्ये जाऊन, किंवा जिथं तुम्हाला तुमचे वकील सांगतील तिथे जाऊन ते रजिस्टर करून घ्या. मग त्याची कॉपी सोसायटीला द्या. आणि तुम्हाला मेंबरशिप जर दिली नसेल तर सेक्शन 22(2) खाली रजिस्ट्रारकडे अपील करता येतं आणि रजिस्ट्रार तुम्हाला मेंबरशिप देतील. आणि तुमचे मेंबरशिपचं नाव आय आणि जे रजिस्टरमध्ये नोंदवलं जाईल. ते जर सोसायटीनं नोंदवलं नाही तर रजिस्ट्रारचा माणूस सोसायटीच्या कार्यालयात जाऊन बसेल आणि ती रजिस्टरची नोंदवही मागवून घेईल आणि त्यात त्या नोंदी करतील आणि ते स्वतः तुम्हाला शेअर सर्टिफिकेट पण देतील. सो तुम्ही एखादा ऍडव्होकेट एंगेज करा किंवा स्वतः जाऊन रजिस्ट्रारच्या ऑफिसमध्ये बसा, तुम्हाला तिथे मार्गदर्शन मिळेल आणि तुमचं काम होऊन जाईल. आणि त्यानंतर तुम्ही कमिटीमध्ये या. कमिटीमध्ये आल्यानंतर मग पुन्हा आम्ही आहे तिकडे, सुनील भाई आहेत, राजीव भाई आहेत, रमेश भाई आहेत, तुम्हाला आम्ही सगळं मार्गदर्शन करू आणि युअर सोसायटी विल बी एन आइडियल सोसाइटी. एक बढ़िया और अच्छा सोसाइटी हम आपकी सोसाइटी को बनाएंगे.
थैंक यू सर.
थैंक यू.
I was seeing one. Mr. Anil has, what are the rights of a co-opted member, whether he can attend office bearer meeting or not?
Co-opted member is कमिटी मेंबर में जिनको कॉप्ट किया गया है उनको उतने ही राइट है जितने कमिटी मेंबर को है. He is not saddled with any restrictions, so to say, and he can participate fully. कोई इश्यू नहीं उसमें. Rajiv bhai, I am seeing one question in the chat box. So we'll take that question as the last question.
Yes, sir.
तो बैजू चेरियन साहब ने लिखा है कि सेक्रेटरी refuses to accept letter wants to put the letter in the letter box. Is that correct? So डिलीवरिंग, जैसे डिलीवरी दी जाती है, कोई लेटर है, कोई करस्पॉन्डेंस है, तो ये रजिस्टर पोस्ट एडी से भेजना चाहिए, ताकि एक्नॉलेजमेंट आपके पास रहती है, एंड दैट इज द प्रूफ दैट द डॉक्यूमेंट और द आर्टिकल इज डिलीवर्ड. सो दिस इज द लीगल सिस्टम. सो सेक्रेटरी साहब, यदि आपको अच्छी तरह से ट्रीट नहीं करते, आपके लेटर लेते नहीं, आपको कोई एक्नॉलेजमेंट देते नहीं, तो अगले इलेक्शन में उनको हटाइए और किसी अच्छे आदमी को बिठाइए. ये एक उसका एक अच्छा सोल्यूशन है. अच्छा, बात रह गई लेटर बॉक्स में डालने की. तो जैसे ही आपके लोकल अरेंजमेंट है उसी में आप करते जाइए, पर हर कोई नॉन इम्पॉर्टेंट लेटर के भी सेक्रेटरी अटेंड करे, तो सेक्रेटरी कोई आपका नौकर नहीं है, ये भी आप जान लेते. तो कोई इंपॉर्टेंट बात है तो ठीक है, पर अनइम्पॉर्टेंट थिंग है, वैसे ऐसे कुछ इंटीमेशन है, तो उनको भी सम्मान से आप सम्मान दीजिए और आप भी सम्मान लीजिए. ये है इसमें. थैंक यू.